Welcome back to Canadian Justice, where we're discussing a recent Ontario case about math, race, and discrimination. Mr. Haradai, I want to follow up with you on the question from the last segment where the Divisional Court had found that this test, which some racial groups were performing failing at a higher rate, they found that this was discrimination. What's your take on whether or not that rises to the level of discrimination in violation of Section 15 of the Charter?
Yeah, so my biggest concern here, Christine, is that I don't want people to interpret either the court's decision or the circumstances around the court's decision as that certain populations, ethnicities, or races are worse at math than others. I think that would be the wrong conclusion. This test wasn't just about math. I think that's important to keep in mind. It was also about, as Asher described, the pedagogy of math. How do we teach math? And so if you have a whole number of people who have learned math differently, perhaps learned math in different countries, it was that specific component of the exam that they were having difficulty with. In fact, there was affidavit information before the court of an individual who knew math very well and passed all the math components, but couldn't pass the part that was about how to learn math or how to teach math.
Interesting. All right, that's an important part of the evidence of the case, that this test had more than just these grade 3, 6, and 9 questions. Correct? There was also a teaching component of it.
Exactly.
Okay.
So, and that has evolved over the years, but also, as you can imagine, people learn math differently. If you're from China or India or parts of Africa, it doesn't mean that they don't know math. It's just that there are different learning approaches towards math around the world.
I think that's an important point. One of the things I want to turn to now is about whether or not, in this case, though, the court appears to have substituted a policy preference for the government's policy preference. The court based part of its reasoning on the fact that the standardized test isn't the best way to achieve higher student scores. That it may not achieve that goal very well at all. But to what degree is that getting into the court substituting its own preferences? Asher, what's your take on that?
Yeah, this is the problem when we interpret discrimination and equality so far beyond what the law actually says, that invariably courts will get into the shoes of the legislature and start making these very complex policy decisions. Like there's no doubt that this is a difficult issue. Nobody's doubting that. Nobody's doubting, I think, in good faith, that this is a problem we need to address. If people from certain groups aren't performing as well on tests as others, that is a problem. But the question of how to address that problem needs to be left up in some sense to experts, but also fundamentally to our elected representatives, whom we elect specifically to address those types of problems. And what the court does in this case is it says, well, this test is no good, but a course would be much better. And a course wouldn't be discriminatory. And the response to that is, how do you know? Why the very same reason that this test is discriminatory, it could turn out that the course is discriminatory. Maybe the course is taught, disproportionately by white people, and therefore white students of that course are likely to do better than non-white students. We have no idea that, and for the court to say, we know this is not good, but we know that this would be better, they are making an inherently legislative choice.
I think that's a really important point. That was part of what the court talked about whether a course itself would be better. But Mr. Haradai, if there was still a disparity in students along racial lines of the failure rates of a course, would the course then be discriminatory as well?
Well, I have a slightly different take than Asher does on this topic, because the Supreme Court of Canada did confirm in a case just last year, Nelson and Marchi, about the type of governmental decisions and policy decisions that are insulated from judicial scrutiny. So there are certain factors, certain aspects that the courts are not going to want to touch. In this particular case, the reason why the courts are getting involved is because the government decided to directly get involved in education. In other words, The arm's length regulator, which didn't want to proceed in this way, was forced to proceed this way because the government enacted legislation. And so because the government is getting involved, they are, by nature of their involvement, attracting more scrutiny about the way that they get involved. And so if the regulator made that decision themselves, I think it would be a different situation.